The name of this panel is Mastering the Arts of Professional Negotiation. Elevate your influence. So we have, I'm going to go ahead and introduce Caren Khoo, our moderator. She is the VP and...
Hi everybody. This is on now, right? Great. Hi, I'm Caren Khoo. I am at Verizon, and I have with me an amazing panel of Kathy Lee and Nick Vogt, who are also at Verizon. And we just wanted to come here and give you a sense of best practices when it comes to negotiations, because everybody has to do it. So before we just get formally started, can I get a sense from the audience, like how many here are lawyers? How many here have a lawyer? Okay, great. How many here need a lawyer? So just to give some background, and Kathy and Nick will introduce themselves in a second. I've been with Verizon for 16 and a half years. Prior to Verizon, I was a patent litigator. And Nick and I are actually the reformed patent litigators recovering, as they say. And at Verizon, I have had over 10 different jobs. And starting from litigation, but all the way through. And what you see today as my title is actually 2 jobs ago, and that was like maybe 12 months ago. So in any event, my job really involves supporting the business on a day-to-day basis and helping the clients that I support achieve what they want to do. And a lot of that involves strategic projects, kind of going across the board, trying to understand what they want to achieve and how to achieve it with our vendors and with our customers. And Nick is at Verizon. He specializes on the vendor side of the house, and so he can give that perspective. And Kathy specializes on the sales side of the house, on the customer-facing side, so she can give that perspective, but both are extremely, extremely experienced, and you're going to be in for a treat today. So Nick, why don't you introduce yourself?
Okay, this works. So nice to meet everybody. Thanks for coming. Thanks for the invite. As Caren said, I'm a reformed patent lawyer, so I was took a different path to go to law school. I was a biology major as an undergrad. I was going to go to med school or dental school, and then my brother convinced me, who was at law school at the time, to go to law school, so it was great. I went, and I've been doing that for 20 years. I have some issues with what he told me, and I'll take it up separately with him after this meeting. But maybe I should go back to dental school. But I at Verizon, it's a great place to work. But I started out being a patent litigator, then I switched over to transactional work. I use my biology background and kind of focus on technology, and so I do technology agreements, digital advertising, software, and as Caren said too, I support the vendor side, so I represent Verizon when we're a customer, and so I negotiate the terms. Do the same tips that we're going to talk about today would be applicable for Kathy, but just have different positions. She's on the sales side.
Hi, I'm Kathy Lee. I am a managing attorney in Verizon's legal department. I've been with Verizon for over 20 years, and I've had a number of different roles, always with a thread in transactional work, from the procurement side to the sales side to public sector. So I've done a whole host of transactions, and we're just really thrilled to be here, because just speaking to some of you earlier, it's such an inspiring group, and we hope that we're able to inspire you in the area of negotiations today.
All right, so another question for the audience here. What is a negotiation? Anybody have a sense of what that is or want to share? Yes.
Trying to find something that's going to be for the best benefit for everybody involved.
Yeah. Anyone else? All right, go for it. Just shout it.
2 people working towards a goal in mind.
2 people work towards a goal in mind. Very similar. Excellent. Excellent. Anyone else? All right. So I think what we just heard was actually like a very common way of thinking about negotiations. You have 2 sides or multiple sides. You're trying to reach a common goal. But I want you to think about negotiation maybe a little bit differently, where negotiation really is the management of a relationship. And negotiating has a number of different meanings, right? And one of those meanings is navigating. So, for example, if anybody of you have read the book Ask for More by Alex Carter, there's also a TED Talk that's currently on TED.com. She talks about the fact that negotiating is kind of navigating through the rapids and the relationships you can get somewhere and kind of influencing that. But let's go to the experts here. So Nick, Kathy, what do you think a negotiation is?
I guess I take more of like because I'm a lawyer, right? So business people have a different, they're thinking more pragmatically sometimes, but I look at it more as like a two-step process. I always think negotiation, the first thing you do is figure out what type of agreement is going to be needed to address the engagement you're entering into. And so I always advise, clients, always use your template. If you have a template that covers the engagement, please use that, because everything should be slanted your way, which is great. And then you start the process. You send the template over, you go back and forth on the issues, and a lot of times you can solve for a deal quickly, just exchanging and going over email drafts of the agreement. 1.2 is I always like to, when I make comments and agreements, always provide some background as to why I'm doing it. Don't just strike something and not provide background. But anyway, once that happens, if you hit like a point where there's some roadblock, then you have to get on a call. You have to go in person, you got to do video, whatever, and then you have to negotiate. And as Caren said, it's a conversation, it's a discussion. And I think that's how I do it. And I think we get to the negotiation point, to make it successful, I believe you have to, one, take care of the business issues, make sure you're caring for what your client wants, make sure you're caring for the pricing and whatnot. You have to cover off the risks, right? Cover off the material risks. Not all the risks, but don't sweat the small stuff, I would say. And then also look at it efficiently. I feel like when I was a younger lawyer, I tried to win on every single point, and I lost didn't see the forest for the trees, right? Always try to, don't sweat the small stuff, cover off the risks, but also approach it as a discussion, right? Don't treat it as a very stressful situation. You're not in court, it's not being recorded, right? If you say something inartful, not a big deal. That's how I treat it.
So negotiations, in my mind, there's the win-win scenario that Nick and I are often engaged in on the sales and on the vendor side, where we're negotiating with the counterparty to enter into a business relationship, after which our clients will continue that relationship under the agreement. And that's classically called a win-win type of negotiation, because we're trying to reach a compromise so that we can enter into a relationship upon agreed upon terms. On the flip side of that, there's also a win-loss scenario. So for instance, if the parties are in an adversarial or dispute situation, it might not be win-win. If one of the parties believes that the other, there was a mistake made, a costly mistake, and one of the parties is alleging claims and seeking to get a lot of money, or they're fighting for land, etc., that means that in order for one party to win, you're going to have to take something, whether it's this microphone. We're going to negotiate, you get the bottom third, we'll chop it up. But that's a different kind of scenario, because I'm not interested in building a relationship. I'm interested in keeping as much of this microphone as I can. In fact, I want your microphone for my client. So it's a very different relationship, and you have to kind of understand what is your objective first and foremost in heading into that negotiation.
Can I just make one point just to follow up on the win-win? I think it's a good mindset, right? So if you're entering into negotiation and you're looking at this as a joint venture, or maybe you're outsourcing a piece of your business to a third-party supplier that supports you, you want to look at it as win-win. You want to obviously cover off all the risks. You want to get the best deal possible for your client. We don't want to make the deal so bad for the other side, such that they're looking to exit in a year, right? And you're right back to renegotiate and try to find another partner. So I feel like that's where the win-win comes in. You want to win, but at the same point, though, you don't want to get blood out of the stone and force the other party to want to walk away. I don't know.
Yeah, I think the irony of all of this is that your contracts are important for your business. That's the language of commerce. But if things go well, you're not looking at the contract. Everybody understands what's happening. People only look at the contract when things are going wrong. So that's something to think about because we spend our time enabling the business to do what they want to do. Each of us has negotiated billions of dollars in deals, and it's always that give and take and thinking about what is the end stage. So what do you consider a successful negotiation? Like my example is having standing drinks, you know, in Ireland, Sweden, the US, wherever we are, like, you know, we took 6 months to negotiate this room, but we're all still friends.
Yeah, I think that's the goal, right? You want to be in a situation where you secure a deal that's best for your client, but also a deal that both parties feel happy about, right? So you make it more long-term. And then, you know, if you're in that, just to talk back to the win-lose situation, sometimes you could be facing situations like that in business deals. You might see that where, like, you have a company that dominates a certain market, so they might approach a deal where they just won't accept any revisions or any position. You can go there and make the best arguments, articulate why you need something, and they'll come back and they'll tell you that it doesn't matter, we're just not going to accept it. It happens sometimes, right? And so ultimately you have to kind of set the goals for each negotiation we think is successful. And just a point, like, always be willing to walk away, right? If the deal's not great for you, especially in a win-lose scenario where the other party's kind of exerting some force, exerting their market power, walk away. Sometimes I found that walking away from a deal, you might get a call a couple days later saying, you know what, like, give me your three best points. That'll solve it. That'll maybe close this deal. But if you just kind of took it and just accepted it, you know, but that goes into like planning. But that's what I think is each deal you're going to have to plan in advance and take it from there. I don't know.
Yeah, I think in my mind, a negotiation is successful if both parties are able to reach agreement on a set of complex terms, understand what the expectations are of each other, understand where the vulnerabilities are. It's very likely in a complex, sophisticated negotiation that both parties will have to agree to some positions that they're not entirely comfortable with. You want me to produce this custom report on service level goals in your format once a month when the reports that we produce for the vast majority of customers are in the standard format that's been automated and perfected over the years. So that custom request, depending upon the leverage of the customer in a transaction, we may have to agree to. But there is some risk in that because it's something that we're not used to doing, but yet, because of the size, the strategic importance of the customer, we're willing to undertake those custom concessions and build practices behind the scenes to make sure that we can comply with those requests.
All right, so we're going to head into more substantive discussion around preparing for negotiation, sort of like the different things to think about, but it is open. If anybody has any questions, please feel free to ask them at any time. We'll also have questions at the end. But this is really for you because we, you know, we do this for a living. They do this more than I do for a living. But I think we're all just here to make sure that you can get something really useful out of it that's relevant to what you're doing. But of course, none of the thing that we talk about is actually legal advice. And we are speaking in our personal capacities, given our experience and our knowledge. You know, some of the things that make negotiation so fraught are emotions. And if you think about what have been the most important deals in your life, you might not be thinking about your business. You might be thinking about things at home, like negotiating the purchase or the rental of your, you know, house or apartment, you know, helping your kid do something, you know. So think about it that way. I think that's where we're coming in with this idea of how do you prepare for that negotiation and what kind of mindset do you want to go in with, right? Obviously, you do want to have as much information at your disposal that you can gather. And then, you know, maybe you guys could talk a little bit about what is the demeanor that you use when you go into a negotiation, and how do you take emotion out of it if you can tell that there's tensions on one side or another?
So a few years ago, we were involved in a large negotiation with a global Asian manufacturer. So 10 representatives from that customer flew from Asia to the United States, and we were sitting in a conference room which had the longest conference table possible. So there were like 10 of them, all men, seated on one side. And we were a much smaller team on the Verizon side. I think there were 5 of us, 3 men, 2 women. And we had planned, there were a lot of issues, a lot of stakeholders who were involved, from finance to IP, a lot of different issues that we prepped for in anticipation. And this was a continuing negotiation, but this was the first time that we were down to kind of the critical issues that needed to be discussed and face-to-face. And so we had undergone cultural training because these individuals were coming from Asia, and it was a particular country where they were not used to seeing assertive women in positions of power. So during this cultural training, the trainers were telling me, Kathy, be you, but don't be you. Meaning, be yourself, but tone it down. Don't be so assertive. So, okay, so the other attorney and I were part of this training, only 2 females in this room. And so we were very deferential, very respectful, a couple of hours in the negotiation and going back and forth very well. It's the issues that we knew we had planned for and we were prepared to give concessions or ask for them. 2 or 3 hours in, we get to one issue, and I can't remember what it was, but it was one of those issues where we absolutely have no room whatsoever to make any concession. So I just said, I looked at them, and I said, well, that's not an issue that we have any ability or any flexibility to negotiate. The man in the middle, whom we had heard from the cultural negotiation was the decision maker, didn't say a word throughout the 2-3 hours. At that moment, he stood up, he started pounding his fist on the desk because I had the audacity to say no to him firmly. So I looked at him, I let him pound his fist. He goes, no, no to no. Okay. So I let him say his piece. What you do when there's a sticky point in the negotiation is typically we let tensions calm down. We might skip over the issue because you don't want to continue a negotiation at that point with tensions as high as they are. Eventually, he stopped pounding the table, he sat down, and a few months later, we did successfully close that negotiation. And I did hear that despite that outburst, and perhaps this particular customer's representatives not used to women, assertive women in power negotiating against them, they were appreciative that there was an Asian woman on the other side of the table who did treat them fairly and somewhat deferentially because of the cultural training. I mean, we're always deferential, but this was kind of, be careful not to be assertive when you are stating firm positions, which is something we do day in and day out. If I were negotiating against Nick, I was like, no way, Nick, that's just not going to happen, move on.
Irritated immediately. I would have left the room and raised the temperature of the room, but just like raise it, to like 90 degrees.
This is your deposition training.
And then sweat them out and then go back in. Oh, please.
I have a question about that experience because my initial reaction would be if someone's being that disrespectful with you, would you ever be like, well, those are just not people we don't want to work with? Or was it something that like you're stuck, there's nothing you can do, you have to work with them? Like, could you just say, your values don't align with what we want to do and we're not going to work with you if you're going to treat us like that?
So keep in mind, I am sales support, so we try to win over customers. And it's going to be a rare case. I've been doing transactions, commercial transactions for in excess of 20 years. We've never walked away from a deal. We have at times felt that way and conveyed that we cannot do this unlimited liability for data security breach for a deal worth $100 million. We're not exposing Verizon's substantial assets to that kind of risk. We will walk, and usually they'll pay. But it's something to keep in mind in the negotiation. I mean, sometimes you can walk away. If it's a vendor where there are 3 or 4 of them in your area for relatively comparable price, then sure, I don't like the way you're conducting yourself, and I'm going to walk away. But this, as I said, was a large global manufacturer, strategic high-profile account, and go ahead and pound. It's not the first time someone pounded the table at me, but he was just a very quiet guy who said nothing because he was the decision maker, and he just jumped up because an assertive woman saying no to him, and it just so happens that I was sitting kind of like directly across from him. It was kind of, it may have been just a cultural reaction though, because usually the folks in the Americans in the negotiations who do resort to pounding on the table or being very assertive, they're like that to men, women, dogs, cats, it doesn't matter. It's not towards the woman.
Actually, you know, Kathy, you mentioned something that I think I want to open the floor for Nick for. You said there are other folks that are in the area where it's relatively interchangeable and you can pick another thing. And I mean, requests for proposal are a very common scenario that you may face as an entrepreneur. You may be bidding on something. You may also want to be issuing an RFP for something. So Nick, can you talk a little bit about best practices for that process?
This wasn't in the.
It was not.
Yeah, it's okay.
It was not. Like, we're going off script.
We're gonna pivot. No, we use them all the time, and I think it's a great way to get the best price, and also to set requirements out in the RFP. You're looking for, you're taking bids from multiple vendors. It's usually a one-way confidentiality thing where whatever they send to you that's your company information. You don't have to worry about. You might have a new idea. It's not mutual confidentiality. So again, you're taking in information or ideas. You get the benefit of that. It also lets you. I always think from the legal side. I'm sorry, not to worry about legal terms, but I always think like with the RFP, it's a good way to kind of attach your template as to this is what we think. This is the agreement that's going to govern the relationship when we give it to you. And we put in the RFP, like if you want your bid, it includes your comments to the agreement. So if we get the RFP response back and they just mark up the agreement pretty heavily, then you kind of know that it's going to take a long time to get a deal done. Maybe it's not the right party you want. But if they come back and say, these are the 5 issues we want, like, okay, we can work with that. It really kind of truncates the negotiation when we get into it. And it's a good way to proceed. We use them pretty regularly. So yeah, I would highly recommend it.
And just following up on that, if a particular company who's bidding on an RFP doesn't have all of the requirements that are in there, should they knock themselves out? Like just say, no, we're not going to bid on this, or do you try?
Speaking from customer sales support, we always try unless we absolutely have nothing that fits. So even if we have 2% product services that meet the requirements, we'll bid. However, if it's an RFP issue for services that we have nothing at all to sell them, then that's a different story though. I mean, I'm interested, how many of you have either issued or received RFPs? Okay, so a few of you, and you know how that process works, but it can be a very effective tool to try to level the playing field if you're procuring, and if you're selling, it's something that we try to avoid because that means you're in a competitive environment, and we try our best to avoid that, focusing on the relationship. So come time of renewal, it's always a goal of our clients to try to seal the renewal without going to a competitive process. We're not always successful. Sometimes large companies insist upon a competitive process to make sure that they're getting the best pricing, the best terms, etc.
All right, so let's pivot back into preparing for negotiation. What are some steps that folks can take to maximize chances of success?
I can hear this one. Okay, yeah, so and we've kind of touched on some of these things before. Kathy was mentioning her negotiation with the gentleman pounding on the table. Was the person a lawyer or a business person? Business person, okay. So then I think it's always good for going to negotiation is to try to identify what are the key points that your adversary wants to win on, their main points, their big risks. Because they're the ones you kind of want to dig in on and kind of like give some friction. So because when you use them to bargain, the worst thing to do is give them all the points that they care about. That's a bad way to start a negotiation. The other point would be to obviously, conversely, understand your risks, what you need to get. What would make the deal successful for you? You should be able to identify 5 or 6 points, and Kathy mentioned one about When she's on the sales side, they're never going to give unlimited liability for data breach. It's just not going to happen. So identifying those points, so you know going in how to kind of set the tone. I also think it's important to know who's going to be on the call. If it's a video call or it's an in-person, and again, back to Kathy's point, she had an idea of who's coming to the meeting. That should set your demeanor, how to approach the call. I always feel like you should get, you have a list of issues that you know you're going to be negotiating. You should get all the necessary parties there on the call or in person, right? So she mentioned IP. You have an IP person, could be a tax person, could be a privacy person. You want to make sure you have everybody on your side. You don't want to just constantly keep saying, we're going to take that back, we're going to take that back. You want to resolve things as much as possible. And then the last point I would say,
Continue and then we'll go to a question.
The last thing I would say is that I try to avoid, if I'm going to get onto a call, and Kathy and I were talking about this the other day, and I see there's a huge group of people on a call, I just want to make sure, and I'll say to the client, are you sure everybody on this call is like necessary and contributing? Because I feel like I've had the experience that we have people that are kind of on the tertiary side of the deal. They might derail the deal, they don't understand the deal, they might kind of make things go sideways. And I also find, I don't do this, I think I'm always respectful and keep the proper tone, but I find that like some lawyers will grandstand. So if you have a large call with their full client base in the call, you might get a lawyer that otherwise might be amenable to your positions. They might sit there and dig and might make negotiation, kind of drag it out a lot. That's been my experience.
There's a question in the back. Actually, there are two questions in the back. So, is there another microphone by any chance that we can continue on? There's three questions, okay? This is good.
Yeah, check 1, 2. Yeah, thank you. I was just wondering, does retrading of deal points that you already agreed on happen? And if so, how do you try to reduce that?
It happens, it does happen, but it's usually some issues where, particularly when two large companies are dealing with one another, there's extensive vetting process. If it's a financial issue, it's the financial organization who needs to weigh in. If it's a tax issue, it's the tax business team, the tax lawyer who needs to weigh in. And so sometimes being in the negotiations, wanting to try to close out as many issues as we can, sometimes we agree to a position and we may have had a discussion with someone, for instance, in tax, but then later when it comes to further vetting within the tax group, the VP might step in and say, no, absolutely not. We're not doing that for them because we've already given them X, Y, and Z. And then we have to go back and then we have to have the mea culpa where you're walking back, you're circling around, of course, but stuff happens on both sides, and people don't be hesitant about revisiting important issues because you may have had additional facts, there may have been additional information that at the time when you tentatively said yes, it seemed okay, but later on you realize that you're giving far more concessions and you shouldn't have to do that. So I think that be selective about reapproaching issues, but and that's how I would handle that.
I think it's a delicate thing to do. Sometimes you lose rapport with the other side if you're constantly reopening issues. You have to have a basis to do it. Sometimes you start a negotiation and the deal changes, right? The deal structure changes, right? You're adding services or components to it that weren't initially there. Then you can say, okay, you know what, this risk that wasn't there initially, that I was fine kind of landing where we landed, we just can't do it now because, like, back to the data point, say now we're sharing customer data with a third party. Well, okay, that's a whole different, list of issues now we need to consider that we didn't consider before. But if you have a situation where you negotiate the deal, nothing's changed, they come back to you and they say, you know what, we just can't give you this indemnity. And I've had that happen to me before. And you're like, this is just a terrible partner. Like, why are we doing business with them, right? Because if they're treating us this way now, how's it going to be once negotiation completes? And in that situation, we did sign the deal, and they were a terrible partner, actually. We ended up moving away from them in like 9 months. So I think it depends on facts and circumstances of the deal.
I just wanted to point out, so one of the areas that I do work a lot in with Verizon is on the internal startups. And a lot of times when you have to retread terms, it's mainly because the businesses aren't clear as to what they want to do, what they want to offer. Maybe the negotiations are starting at a very early stage. And you realize after you've had several conversations that you're not actually ready to get to something super binding. So what do you do in that situation, right? You have to have the idea that maybe you want to step back. Maybe you do a letter of intent. Maybe you do a memo of understanding that's not binding, but at least shows a meeting of the minds of the companies to go in a certain direction, and then have a plan before you deliver substantively because, right, cow's milk free, all that stuff. You want to make sure that you have an agreement in place that actually does protect not just your interests, but the other party's interests, but also makes it clear what you're doing, right? So I would say like that early stage structuring is super important to think about, and as you're working with your lawyers, making sure that they're aware of that entire big picture is such a great partner to have for you, because when they know the big picture, they can keep that in mind as they're fighting over what one term or another. But the other thing that you should be doing is looking at the contract as a whole, right? So what Kathy said, what Nick said, if something changes, it might affect other terms, and that's a reason to retread. To say, you know what, I know this happened, but we've made these changes. We have to go back to adjust to make sure that it matches, right? The risk matches what we're delivering. But that's, really just reading. It's reading and comprehending and having that big picture in mind as you go in. All right, there are 2 more questions. You had a question? Yes. Yes, we
Okay.
just stand up.
Okay, yeah.
Do you have a microphone?
No, it's okay. I can try to project myself. So I've heard a lot about the planning aspect of it as well as the flexible aspect of it. But in terms of being flexible, right? When the pressure's starting to rise, what goes on through your mind to stay grounded and really just handle that stress that goes on in these negotiations?
I think the most important thing you can do, Caren and Nick alluded to that, you have to plan and prep for the negotiation. So in this deal, what are the top 5 or 10 issues? Looking at everything that's been discussed, business terms and contract, what are those top issues for you? And conversely, what do we think, based upon the initial discussions, are key issues for them? Because those are the ones that you're going to want to dig in, slow down the concessions, but everything else, as Nick said, you probably are going to be fairly flexible about. And I think that if you don't look at the issues as all the same, so in our global sales service agreements, these go on for months or years at a time, they're innumerable issues. But if we're going to fight over every single paragraph, every single sentence, it's just not worthwhile. But certain issues are really important to us, like not being exposed to unlimited liability for a data security breach, which are very prevalent concerns globally these days. So make sure you understand those issues for you, make sure you understand their key issues, and then everything else, you're probably going to have more flexibility. Does that help?
Yeah.
Yeah.
Thank you.
Like I was saying before, it's good to build consensus. I think you can build momentum sometimes on deals where, and Kathy mentioned there's some points in the agreement you don't really care too much about, and there are the ones that maybe, so you start out with an issues list and there's like 30 issues, like, you know what, actually 20 of these we probably can meet full consensus. Well, keep the ones that you're really digging in on, and then solve the ones that are pretty easy to do. And then you might find like other sides that, okay, we can do business with these people, like they're actually pragmatic, want to get the deal done. That's a good way to kind of build rapport, build momentum, and then handle the tougher ones. And I always feel like too, and when I was younger, I was terrible at this. So keep your emotions in check, right? There's and just be yourself. I feel like if you just be yourself, don't keep your same persona that you have on and off the call, and just be confident, right? And if you have to stick firm on a point, you stick firm on a point. No reason to get animated or scream or to bang your fist. I feel like that actually is not helpful. They get at it. Derails things I've had lawyers, use profanity on calls, insult my clients, stuff like that. Things that I would never do. And you just hang up the call. You just close the deal, and it's There's no point. You don't take that, right? You don't need to, return serve. I think that's not the way to handle it.
And once you identify those issues, the timing and the pace of when you introduce them is important. You're not going to start the first few rounds of negotiations with those issues. What you want to do is kind of start with the easy ones to build momentum, to see that we can work together, because now we've agreed to half of the other issues, right? So this is good. But if you start off with the unlimited liability for data breach, and that goes on for 20 minutes because now your side will yield, the impression or the misimpression could be that we can't do a deal because these people are inflexible.
But everyone has a point.
And so often we will pace the negotiations. We will try to figure out if there are more than one attorney or clients in the meeting, like who's better equipped to deal with that issue, who has a better rapport to deal with that issue.
Yeah.
Because it may be that the non-lawyer can deal with the business issue, a tough one, because they've been talking about this. So you want to pick your best tool, your best person to go and be the mouthpiece for those issues. And typically in a negotiation, we like to pace things. So at the outset, we'll roll with the easy issues. When you get to the tough ones, we'll spend some time, but if both sides are digging in, we'll just skip over that and we'll come back to that. See what else we can cover, because the closer you get to the finish line, the more motivation there is on both sides to close out those remaining issues that are key to both sides.
Yeah, I just have two very short, direct points. Take a break and make sure that you are aligned on your side. You don't want to have folks representing you or your own partners asking questions that they don't know the answers to on mixed calls. You want to make sure that there is coordination, and so if those questions come up, like do it on the chat, right, on the side, not probably in the conference chat because it's very easy to text everybody. But just have that ready in your negotiations. We use breakout rooms a lot, but now it's all a virtual world, and so the breakout rooms are side slacks. Anyway, but hopefully that helps. Question. We only have a few minutes left, but let's go with the question there. Yes.
Hi, my name is Yale. I've actually worked with Verizon in the capacity because we, 2 startups ago, we were actually a portfolio company of the Verizon Fund.
What's the name of that one?
Our company was called Split. We had a software for transportation. We were eventually acquired by Robert Bosch, the German maker of washing machines.
Congratulations.
And somebody at Verizon actually did grandstand when we were getting acquired because they're like, we're a really big company, and Robert Bosch is like, we're a really big company too. And so they were holding up the deal, but that was actually not my question. I'm just saying
that person's no longer at Verizon.
I did get to go to the campus at Basking Ridge. It was really fun. The question is actually, as a tech startup, we're often faced with some really prejudicial and unfair documents. I'm going to give 2 examples. One is an unnamed Japanese car company, for example, would ask us to sign a one-way NDA in which they basically have the rights to everything we're disclosing and everything we're inventing. And we really want to work with them, and so that's one question. How do you deal with that? And number 2, sometimes we have to work with professors at universities where we're trying to license technology, and the professor's like, I've been working on this for 15 years and I need half of the company, or we're not going to give you this technology. And I'm like, yo, respectfully, doctor, we'll take it from here is what I want to say, but obviously can't say that. So, 2 situations, unfair NDAs,
Okay, if I take this one.
selfish professors, how do you deal with things while you're still trying to execute and stay alive as a startup? Okay, thank you.
Okay, NDAs. This one, I think there's a lot of support, through the business relationship. So as you're talking to the folks who are running the business, they're probably not involved in writing the NDAs. They may not even know what's in the NDA that was sent to you by one of their partners or they forwarded from the legal department. Usually, if you have that conversation with the business folks, they can see the equity of the situation and they can help negotiate for you with their internal legal department a concession or at least a mutual NDA. or some limitations on the fact that you have IP in this situation and you want to put some protections in around that. So I think that really, one, having good representation, but also having a really good relationship on the business side can often achieve the goals that you want on the NDAs. On the university issue, that is one of the hardest IP issues in transactional, IP world things there are. Often universities have agreements with the professor that require the professor to assign IP to the universities. Often the professors themselves have their own goals that they have some rights to be able to retain. In those situations when you're using, when you're talking to universities, I really do think that you should have an ongoing relationship with an excellent IP lawyer who's familiar with these issues and has dealt with universities before. And they're out there. That is actually one of the hardest things to navigate. I think what you can think about is whether or not you can do some directed research so that you can own the IP, whether you can fund something so that the students can do something. You have to think about different ways, but I mean, baseline, the universities have these agreements that you may never see in terms of what the work obligations are, but sometimes the professors will share those with you as well, kind of on the side, so you have that knowledge. But that's how you have to kind of approach these. There's so many different ways to slice it, or you can just be more limited, something through another company, or through a challenge or a contest. So anyway, there are a lot of different options you can take, but universities are super hard. You just have to kind of know what you want to give and know what you don't, and then if it's not tenable, think about walking away. That one is actually, because universities are also very litigious and well funded.
Yeah, we're thinking about walking away right now. Actually, I'm actually literally writing the SWOT.
All right. So I know we have another question in the back, but we're probably at time. Can I just ask for a couple sentences, best advice to folks who are starting out or have complex issues? What do you want them to walk away with?
I would say prepare, know your issues, know the players, who's going to be present, and don't be hesitant to ask. I mean, even though there's a disparity in leverage between a startup and Verizon, for instance, we do get requests all the time. The worst that can happen is they can say no, or conversely, a mutual NDA should not be a big lift at all. I mean, that's kind of, if you ask for it, you'll get one, typically. So some things are common sense, and other things, if they're important, particularly if you have other choices, don't be hesitant. Even our small business segment, they do have some concession for some opportunities to make some, to agree to some concessions.
I would say, just to echo that, you hear businesses say some of the time, they'll say, well, we never do this, we're never going to do this. And then the reality is they've done it before, right? I mean, it's one thing to try to change the terms to Google search. That's one thing, they're not going to probably change any of the terms. But I think most businesses, they have done mutual NDAs before, maybe go in with no NDA and just kind of free flow. But just from the negotiation point, just something I would just add in is that be prepared. Always ask a why question. I always feel that's a good question to ask in negotiations. It puts the other side on their heels, and if they can't justify, can't explain why they need this or why your position is so wrong, that's a good way to do it. I've had this come up sometimes where they want to cap liability, they're not responsible for this, not responsible for that, and I was like, I say, okay, well, you're really saying that if you do X, Y, and Z, and somehow we get fined by a governmental entity, we're not going to be covered for that. So basically, your non-compliance with the law is going to create issues for us. If you kind of if you can get them to kind of explain open-ended questions, the why, push them to explain their positions, listen to those responses. I feel sometimes I talk a lot, so I have to kind of get myself and say, just listen, be quiet and let the other person listen. I mean, let the other person talk, because you'll hear stuff about what their concerns are, what they feel about our positions are. If you can't justify it, it's a way to win an argument. And the last point too is always, on the points that are important for you, always remember to anchor. And that's sometimes when I was younger, say we wanted some provision, say, okay, we want 1 year exclusivity, and they come back back with like, we'll give you 30 days, and then they'll say, we'll meet you in the middle, and we'll do 6 months. And it's like, if you really want it, you come back and you say, I want a year. That's what we want. So anchoring and asking why questions, I think, were really good. I didn't do them a lot when I was younger. I had to do them all. That's kind of a part of the modus operandi now.
That what Vic just said is, if you take nothing else away from this panel, I think that is a key piece of advice, because often you will we absolutely can't do that. That's one of the most important issues to us. And then if you're poke at it, can you explain why? They're not, if it sounds unreasonable, they're likely not going to be able to explain why. We just did this with a very large auto manufacturer where they said that was this issue they would never yield on and is critical to them. So I started poking at them and my team about, well, can you explain why? And why is that not covered by general compliance with laws? Why do you have to have that? And then after 6 or 7 inquiries, the other attorney couldn't answer the question. So I said, well, then isn't that just an ordinary breach of contract at the end of the day? It was silence. So the power of why. Don't react to the no matter how hard you're pounding on the table.
So if I really leave Verizon and then I get on a call and Kathy's is the adversary, I won't be joining Kathy. but I think asking questions kind of extracts information out. I've had situations where, just from the software agreement, where you have the software provider and you pay for enhancements to their platform. They'll say, we always have to own them. We always own them. We have to protect the sanctity of our product. We'll never give you rights to them. And that's a hard line. If you keep asking, well, why? What's the point? Keep pushing them. And then you might say, you know what? Fine, we'll let you own it, but maybe give us exclusivity around our customer base or around our competitive base. So you can kind of have the ability to kind of cover off your concerns, but also cover their concerns. And if you don't ask them and press them as to what their main concern is, you won't know it. And you always can be flexible. There's the one thing we used to be patent lawyers. There was like, be your own lexicographer. Was that the one?
Yes.
Right. So basically, you can write. You draft a patent. You can write it any way you want. You can describe your invention any way you want. And same thing with a contract. You can write every clause any way you want it. Right. So it's not. So the only way you're going to find ways to revise, adapt, is by pushing the other side, figuring out what their issues are.
Yeah. Well, in closing, I just want to say thank you so much for being such a hot bench and like asking tons of questions that are super interesting and difficult to answer.
Yeah.
And
especially the university one, happy to pick up one.
So old job, right? But as everyone said, be prepared. Know what you're doing, right? And that doesn't necessarily mean in the negotiation, but know what you're willing to give, know what you can give, know what you can't. Stay open, assume positive intent, but be prepared and appropriately skeptical. Not cynical, but skeptical, because again, if all goes well, this is going to be great. You're on to the next relationship. It's going to be a long-term thing. If all goes bad, everyone's going to look at the words on the paper. So anyway, thank you so much. Thank you.